Penguin Random House Audio presents The Agenda: How a Republican Supreme Court is Reshaping America by Ian Millhiser. Read for you by David H. Lawrence, the 17th. Introduction. From 2011, when Republicans gained control of the House of Representatives and denied President Barack Obama a governing majority, until the pandemic forced Congress's hand in 2020, Congress enacted hardly any major legislation outside of the tax law President Donald Trump signed in 2017. In the same period, the Supreme Court dismantled much of America's campaign finance law, severely weakened the Voting Rights Act, permitted states to opt out of the Affordable Care Act's Medicaid expansion, created a new religious liberty doctrine, permitting someone who objects to the law on religious grounds to diminish the rights of third parties, weakened laws shielding workers from sexual and racial harassment, expanded the right of employers to shunt workers with legal grievances into a privatized arbitration system, undercut public sector unions' ability to raise funds, effectively eliminated the president's recess appointment power, and halted President Obama's Clean Power Plan. Plus, lest you think that the last decade was a never-ending stream of losses for liberals, the court held that every state must permit same-sex couples to marry, and it held that federal anti-discrimination law prohibits employers from firing individuals because of their sexual orientation or gender identity. The Supreme Court, in other words, has become the locus of policymaking in the United States. The lion's share of the legal changes that have occurred over the last decade were spearheaded not by elected officials, but by the 9 unelected members of the nation's highest court. And with Republicans now controlling 2/3 of the seats on the Supreme Court, the court could potentially sabotage any policy initiative pushed by President Joe Biden. It can also manipulate our voting rights laws to ensure that Republicans dominate future elections. Part of the explanation for the shift in power from the elected branches to the judiciary is that congressional dysfunction fosters judicial dominance. As Professor Rick Hasson explains in a 2012 study, Congress is now nearly 80% less likely to enact legislation overriding a Supreme Court decision than it was several decades ago. Hasson defined the term override to include any successful piece of federal legislation that overturned, reversed, or modified a Supreme Court statutory interpretation holding. Between 1975 and 1990, Congress enacted an average of 12 overrides of Supreme Court cases in each 2-year congressional term. That number shrunk to 5.8 overrides for each term from 1991 to 2000 and to a mere 2.8 average number of overrides for each term from 2001 to 2012. As Congress has grown more partisan and more polarized, Hasson explained, it's become less and less able to form the consensus necessary to override an erroneous Supreme Court decision. Though there are still rare cases where a single political party controls both Congress and the presidency, and the members of that party agree that a particular Supreme Court decision should be overruled, partisanship seems to have strongly diminished the opportunities for bipartisan overrides of Supreme Court cases, in which Democrats and Republicans come together to reverse the Supreme Court. As Congress grows less and less able to enact ordinary legislation, the Supreme Court is more and more likely to become the final word on questions of policy. Hasson's study, however, only offers a partial explanation of the Supreme Court's increasing dominance. Congress, after all, only has the power to override court decisions interpreting or misinterpreting a federal statute. When the Supreme Court declares a law unconstitutional, that decision can only be overruled by the Supreme Court itself, or, in extraordinarily rare instances, by a constitutional amendment. The full story of how the Supreme Court grew into the most important policymaking body in the United States is also a story about partisan polarization. It is a story about how the justices and the men who appointed those justices themselves became polarized. For much of the last several decades, Democrats and Republicans largely shared a bipartisan consensus that the courts should play a limited role in society. Indeed, if anything, Republicans tended to be more skeptical of judicial power than their Democratic counterparts. President Richard Nixon campaigned against judges who impose their social and political viewpoints upon the American people. President Ronald Reagan promised judges who would exercise judicial restraint. President George W. Bush warned of judges who give in to temptation and make law instead of interpreting. Indeed, until very recently, conservative lawyers organized around the principle that courts should be very cautious about exercising too much power. In a 2006 address to the Conservative Federalist Society, for example, former federal appellate judge and then Secretary of Homeland Security Michael Chertoff credited the society for catapulting arguments for judicial restraint into the legal mainstream. In large part because of the work that the society and others have done, Chertoff claimed, the claim for judicial modesty is sufficiently well established that everybody understands, even the critics of that claim, that they have to take it seriously and they have to address it. But judicial modesty is now very much out of fashion in conservative legal circles. Many of the same men and women who spent the second Bush administration arguing that judges need to exercise judicial restraint are now the most vocal advocates for increased judicial power. In 2005, for example, future Justice Neil Gorsuch denounced American liberals who have become addicted to the courtroom, relying on judges and lawyers rather than elected leaders and the ballot box as the primary means of effecting their social agenda on everything from gay marriage to assisted suicide to the use of vouchers for private school education. And yet, as a member of the Supreme Court, Gorsuch has called for the judiciary to claim a broad new power to veto federal regulations. He's argued that courts should give Christian conservatives broad exemptions from the law, and he's even suggested that the court should revive an antiquated freedom of contract doctrine that it once used to strike down basic labor protections, such as a minimum wage. Indeed, Justice Gorsuch, who once accused liberals of using litigation to implement their policy preferences regarding private school vouchers, joined a Supreme Court decision forcing states with voucher programs to provide such vouchers to religious schools. So, what happened? How did a political party that until very recently was very fearful of judicial power learn to stop worrying and love judicial activism? To answer this question, we need to examine more than a century of Supreme Court history. The Golden Age of Conservative Judicial Activism. If you ask me where American aristocracy is found, Alexis de Tocqueville wrote in Democracy in America, my reply would be that it would not be among the wealthy, who have no common link uniting them. American aristocracy is found at the bar and on the bench. Lawyers, according to de Tocqueville, are secretly opposed to the instincts of democracy, their superstitious respect for what is old, to its love of novelty, their narrow views to its grandiose plans, their taste for formality to its scorn for rules, their habit of proceeding slowly to its impetuosity. The law, or at least the law as it largely existed in the early American Republic that de Tocqueville observed, was much less a creation of democratically elected lawmakers than it was the slow, iterative creation of judges, who by deciding individual cases
Sample complete. Ready to continue?